Today I want to talk about using Realtor association contracts to wholesale real estate. Generally, that's not the preferred method of entering into a contract that you're going to later assign. I generally recommend having a customized contract or a contract specifically purchase contract specifically drafted to deal with wholesaling. But nevertheless, I have clients, and I personally know real estate investors who use the association forms and are successful at wholesaling. The first recommendation would be to make sure that any state required disclosures are put into that contract. So a specifically drafted, wholesale contract that should be state specific. It's going to have the required language of the state or disclosure language that needs to be in there. For example, Arizona just passed a disclosure law that requires buyers to disclose whether or not they're going to or intend to assign the contract. And if they don't have that required disclosure language, then the seller can freely, back out of the contract and keep the buyer's earnest money in the process. So you want to make sure that if you do use the Realtor Association contract, that you're going to have a provision in there that discloses whatever you need to disclose pursuant to state law. The other issue that comes up with using a Realtor Association contract is the fact that it's not going to have a specific assignment provision in the document. It's just going to be silent, or at least here in Arizona, our association form is silent on assignments. So the question is, okay, well, as a buyer, can you then assign? And the answer is generally yes, but basically there's three factors that we look at to determine whether a contract is assignable. So in Arizona, pretty much every contract you enter into is assignable and there's three things that would make it so that it can't be assigned. So the first thing is that it materially changes the contract or puts an additional risk on the other party to the contract. So the party that's remaining in the contract that's not assigning their interest, that, is it going to materially change that contract? Is it going to put them at greater risk of, of not having the other party perform? Is it going to somehow damage them? Is it going to increase their burden in some way under the contract? Generally, an assignment will not do that, especially if the contract provides that it's a cash transaction. The end buyer is going to purchase it in cash. It's not going to be contingent upon any type of financing. There's no material change there to the contract. And so that element would be non-existent. And so the contract would remain assignable. The second is whether or not the assignment is forbidden by statute or by public policy. There's no statute in place prohibiting the assignment of real estate purchase contracts. In fact, on the commercial side of things, I do a decent amount of commercial due diligence, and I work with buyers and in assisting them with buying commercial real estate. And on the commercial side of things, it's uncommon to purchase the property in the original buyer's name.
Sure.
Normally, you have a sophisticated buyer that has a entity that they use to enter into the purchase contract, but then they want to do some asset and tax planning on the back end. And so they go and form another entity, and before closing, the contract's assigned to that other entity. So this happens all the time in the commercial space. And so the same would hold true with the residential. There's no statute that prohibits or there's no public policy grounds, at least here in Arizona, that would prohibit the assignment of a contract that doesn't otherwise have a assignment clause. And then finally, is this assignment specifically prohibited by the terms of the agreement, right? So if the purchase contract were to state that, buyer may not assign this contract, well, then they can't assign it. But absent that language, then it's fully assignable. So basically, you can use a contract that's silent on whether or not it can be assigned, as long as the assignment does not materially change the terms of the contract or burden or affect the non-assigning party. as long as the assignment's not prohibited by statute or public policy. And then third, that the assignment's not expressly prohibited by the terms of the contract.
And of course, we've discussed in other shows why, if you're using your own improved and created purchase contract, there's some assignment provisions that we'd recommend even adding to that. But this really being in the event you're using a form contract that doesn't address it, you still have the ability to assign so long as it isn't prohibited otherwise.
Well, and at least here in Arizona, it has that state required disclosure language.
True.
Yeah.
Because then the if it doesn't, right, the buyer can pull the plug on the deal.
Correct.